A very good morning to one and all present here, and welcome to the India Idea Week 2024 in Mumbai. I would now like to invite Mr. Vikram Nankani, MCI Council Member and Senior Advocate, to introduce the judge.
Good morning, everybody. It's such a pleasant surprise to see a full room in Mumbai on a Tuesday morning, and very rarely do you get to see such a full room. So thank you very much for coming, and I have been given the difficult task of introducing Justice Pitale. The reason why I say it's difficult is because when we reached out to his office for his profile, we were told to look up the Bombay High Court website. I mean, that doesn't make me wiser because all of you can go to the website and make me redundant. So really speaking, that's his modesty, and that's the judge that we see every day in the court. He's a living example of that modesty. He started his career with a very eminent senior counsel, Shri Hari Ane, who is the former Advocate General of Bombay, or Maharashtra, if I may call that correctly. Then he went on to join the chambers of Mr. A.K. Sanghi in the Delhi Supreme Court and practiced there for a number of years until he was elevated in 2017. All that I can wish is that looking at his date of birth, it should not be just 2032, it should be 2035, that he should remain with us as a judge. And in the short span that he has been on the bench, like someone was saying this morning, practically every subject he has touched upon, whether it is civil, corporate, commercial, IP, arbitration, criminal. Currently, he is doing criminal assignment. That shows the versatility of the man. And without much ado, may I just invite Justice Manish Pitale to deliver the morning address.
Careful. Good morning, everyone. I think Mr. Nankani has been very generous in introducing me. And I should be humble, I think, because every day I sit in the court, I hear counsel arguing, and not just senior counsels or those who have made a name for themselves at the bar, but sometimes a very young lawyer also comes up with a very interesting argument. And every day you learn something on the bench, I'm sure also in the bar. I have been lucky, I must say, that I've been assigned various assignments by successive Chief Justices. I've had the chance of sitting at both the benches. Nagpur was my headquarters till about 2 years ago. And I was sent a visiting judge. We have this concept that because we have two benches and a joint high court with the state of Goa, so judges can go for assignments of 3 months, 12 weeks, etc. I was sent for 6 months to Goa. And my colleagues at Nagpur said that you'll have a great time there. I said, no, I'm going there to learn something. And believe you me, in Goa, if you're ready to work hard, the bar also supports you. It's a misnomer to say that in Goa, people just take life easy. The members of the bar go home after lunch. No, they do work hard. I sat there till 7 in the evening, and lawyers were arguing matters in my court. Portuguese law, environmental law, so much to learn. Mr. Nankani has been appearing there. I remember you appeared in a IT matter, and I had referred it to a larger bench. But before the division bench could decide the issue, I think it was decided by the Supreme Court. So therefore, that's the end of the controversy. It's been my fortune that I could work on the side of arbitration as well. And I could know from close quarters what are the difficulties that are being faced. And that's the reason when Neeti mentioned about this ADR week that is organized as an annual feature, I guess. This is the 4th edition, and it's great. It will be spreading awareness, not just amongst practitioners, but I'm sure amongst other professionals as well, as to what is ailing the process of arbitration in our country. And I've said this before, that arbitration has not failed in India. We have failed arbitration. It's because we have treated arbitration over the years as a post-court work phenomenon. And now I am happy that finally we have a arbitration bar with Gaurav heading it, Gaurav Banerjee. So we are in safe hands, I guess. And the idea is to have a dedicated bar. And I was just looking at some of very interesting topics I found were arbitration and mediation as complementary process. Med-arb or arb-med, the way you look at it. But I would prefer med-arb because I have this belief that mediation must be the starting process. If the dispute is resolved through mediation, then it's a win-win situation for all the parties. But even if it's partly successful, it brings into focus the points of dispute resolution. And therefore, the arbitration gets limited to only those points in focus. The arbitration can therefore proceed quickly and hopefully in an inexpensive manner. If you don't engage counsel like Mr. Nankani, then it's... But it becomes simpler, is the idea. But there's one issue that always comes to my mind because there are 2 points of view on this, that whether a mediator, once he's gone through the process and it's only partly successful and the dispute resolution requires the process of arbitration, should the mediator act as an arbitrator? Now, my personal view is that it would be fraught with risks because the process of mediation is different, it's unique in the sense that the mediator more often than not interacts with parties individually, and parties, by the very process of the mediation, they divulge certain their trade secrets and certain information that is very close to their business. And I'm not saying for a moment that the mediator would share it with the other side, but when the same mediator proceeds as an arbitrator, there could be a chance of an unconscious bias. There could be a chance of, the mediator not being aware of the kind of bias that might develop in his thinking because he's privy to so much more than the information that would be available in a contested arbitration. So for me, I think unless I'm convinced otherwise, the mediator should stop if it is only partly successful, identify the points of dispute resolution by arbitration, and then hand it over to the others. If I'm not wrong, in the MSME Act, in the Facilitation Council, if a member has acted as a mediator, that member cannot act as an arbitrator. So that's a ground for challenging an arbitral award. So that session should be very interesting. I think these are one of the issues that should come up. And of course, the question that always troubles the courts as well as counsel about whether the court should have a power to modify an award. We have NHAI versus Hakim, Justice Rohinton Nariman's famous statement that there's a Lakshman Rekha that can't be crossed. And it started from McDermott onwards. I found sometimes as a judge, as a court, I feel helpless because I see that a little bit of tweaking will do justice. But because there's limitation on the power of the court as per the law laid down, you can only set aside an award or partly set aside an award. Should there be an amendment to bring about power of modification? Because the UK Act does have it. In section 67, they say you can vary an award. Now that power is not there with the Indian courts. But I remember a matter I was dealing with in Nagpur, where the National Highway Authority of India had acquired certain pieces of land. The landowners had very small pieces, 1.5 acres, 2 acres, etc. They were up against this behemoth of National Highway Authority. They have a number of lawyers assisting them. And the arbitration process went on and came to my court, where I realized that the arbitrator had gone wrong. So even under the narrow scope under section 34, the award could be set aside. But I thought that a little bit of tweaking would help the landowners. For instance, at that time, the Land Acquisition Act, the earlier Land Acquisition Act was to be considered. And there you have statutory reliefs. You have 12.5% of interest, you have solatium, etc. On one of those factors, which are statutorily available to the landowner, the arbitrator had missed out, perhaps erroneously. And they had raised that as a ground, that please give this relief to us. And the National Highway Authority Council just stood up and said, all right, let's set aside the award on that ground so that we go back for arbitration. Now, this becomes a little unfair. So I thought over it, I mulled over it, I reserved the matter, and after 2 weeks, I gave a judgment where I gave them that relief, the landowners. I knew this is going to be challenged in the Supreme Court. It was, and it's now referred, one of the matters which is referred to a larger bench by Justice Datta's bench, whether there is a power. You know, the whole point is that if you are so strict about it, then the only way the thing can be resolved is another round of arbitration. And in this country, how many people can afford rounds and rounds of arbitration? That's something which we will have to discuss. And such ADR weeks, I'm sure you come out with your papers or whatever, the speeches that have been delivered. Looking for a solution, these ADR weeks can act as material for the government to think over, the legislature to think over what changes are to be brought. Because this is something very crucial. If you restrict the power as it has been restricted today, then the High Court feels that it is restricted, although it's a court of record. We know the kind of power that the High Court wields, or even the Supreme Court. But if you can't tweak the award for the ends of justice, then is it being too strict as a statute? But the other side is that if you open it up, then it becomes an appeal. Then you go back to saw pipes regime. And we've seen it was saw pipes judgment created havoc, which brought about the 2015 amendment and so on and so forth. So it's a fine line. If you provide for power to vary, as in the UK Act, what is the limitation of the power of the court to vary or modify? This far and not further. Who will decide that? Because once you give it into the hands of the judge, then what for me meets the end of justice may be different for another judge. So then it becomes very subjective, and we don't want that in an arbitral process. So that's one big challenge you are looking at. I think this should be a very, very interesting session. Then there's one on experts as arbitrator and arbitrator-appointed experts. Now, experts as arbitrators are obviously required where the subject matter is highly technical. A generalist may not be able to even comprehend the technical terms. It's necessary to have expert arbitrators. But I have seen this because when awards come for challenge, you realize that experts are experts in their field, but sometimes they don't, or they are not aware of the basic principles of natural justice, procedural law, and their technical knowledge is sound, but the award is set aside because they didn't have knowledge of the basic rudimentary principles, legal principles like natural justice, etc. So I always feel that where experts are involved or a highly technical subject is involved, you can have two nominee arbitrators who are experts, and they can choose an umpire or a third arbitrator who's necessarily a person with a legal background, maybe a counsel or a judge, retired judge, so that there's some balance which is maintained. It's true about experts in any field, even in our field. I feel there is lack of humility amongst experts because they think they know a lot. I'm sure they know a lot, but that brings about a bit of lack of humility or perhaps sometimes even arrogance. So when matters are argued and they are shown the other side of what their thought process is, they are blockheaded. They don't just accept what's happening. So I'm always reminded of what an Australian judge told me. I had gone for a WIPO masterclass to Delhi, in the Delhi High Court. I was nominated by the Chief Justice. You had the judge, I'm sorry I'm forgetting her name. She's the very judge who decided the matter of an Indian wrestler recently in the Olympics. She gave us a lecture on hot tubbing. So that's, of course, an Australian concept which has now become a global concept. So we can think of discussion while you discuss experts on what is hot tubbing and how it can assist the process of arbitration. I also saw a reference to India as its unprecedented rise in recent times and how the process of arbitration can adversely affect or positively affect the superpower that India intends to become. There's no doubt that India is rising technologically and as an economic superpower, but unless you have dispute resolution mechanisms which are quick, the extent of investment will not be as much as it is expected. And India may not be able to realize its potential if investors feel that they will be caught in the quicksand of court proceedings, or worse, the quicksand of arbitral proceedings. Because if the arbitral proceedings are mirroring the difficulties that courts are facing, then the whole idea of arbitration fails. The court system, as we all know, is creaking under the burden of pendency. In benches like Nagpur, perhaps a judge is more satisfied because your days matters that are listed, all of them reach, you pass at least in half of them effective orders, and then there are days when you take up final hearing matters. In the principal seat, it's not happening at all. You have, with the result, I am today holding the anticipatory bail assignment. Matters are necessarily urgent. They concern the liberty of individuals. They're far more important than commercial matters. But the position is such that my regular board won't reach now because my supplementary board is swollen to 30 matters or 35 matters, all of which are urgent. So there are days when out of those 35, I will have finished about 32 matters in which about 28 or 30 matters I will have passed effective orders. But those 3 or 4 remain, which are pushed off to the next date, which is the same week. But the judge at the principal seat goes back home a lot more dissatisfied because you have lawyers mentioning matters the next day morning that even my supplementary list didn't reach. So you're falling short because the assignment that I am holding, for instance, it will need at least 5 judges to do justice to that assignment. Likewise, arbitration matters, IPR matters. There was once, I heard a complaint at the bar that a lot of IPR matters are going to Delhi High Court. Not necessarily because the judges are better, they're very good, they're competent, but because they have a commercial division there. So the high courts have to really think about these policies. In Mumbai, can we spare judges for an exclusive commercial division? We can't, because then who looks after bail, anticipatory bail, etc.? PMLA matters, very tough. Now, of course, the drift of the law is changing a little bit. The stringent tests, statutory tests are being diluted in a way because trials go on for years. You can't have under trials languishing in jail. So when we think purely of commercial arbitral matters, we have to look at it from a holistic point of view that for the parties involved in a commercial dispute, it may be very important. But look at it from the point of view of the court. Because the court is to consider all disputes that reach the court, and absolute priority has to be given to matters which involve the personal liberty of individuals. You have 94 sanctioned strength of judges for Bombay High Court. Today we are 66. By Thursday we will be 64 because 2 senior most judges are moving out as Chief Justices of Madras and Kerala High Court. So these are all issues that we face day in and day out. And when you look at these issues, these problems, and if you look at it only from the point of view of the bar or the lawyers or the litigants, then you miss the whole picture. The WIPO masterclass I'm talking about, there was a professor from UK, I'm very poor at remembering names, but he was a great expert who, it was on artificial intelligence, part of the session. So he said, the moment you talk about artificial intelligence, let's be clear, we are not replacing judges. Artificial intelligence cannot replace judges, but it can assist the process. You have documents running into thousands and millions of pages. You will have artificial intelligence identify where an issue has been discussed, where is the relevant portion, etc. So it can be used as a system which can enhance the efficiency of the process. And he said, we are all asking wrong questions. One of the questions which is asked in the context of artificial intelligence is, what happens to the lawyers? Will they lose work? Etc. So he said that's the wrong way of looking at it because the whole purpose of this process is to resolve disputes. So the litigant is the central focus. So it doesn't matter what process you use, the process that you use must be the most efficient available. So if you look at it from that point of view, then some of the debates pale into insignificance. But you have to really focus on what will make arbitration successful in India. And as I said, the culture has to change. You have to have arbitrators who are professionals. Now that brings me to a concern that was flagged by our Chief Justice in the recently concluded arbitration conference at Delhi. It was, I think, the Permanent Court of Arbitration opening an office in Delhi, 125 years of the Permanent Court of Arbitration, 75 years of the Supreme Court, sort of joint conference. There, our Chief Justice touched upon a topic that, what about the conduct of arbitrators? is it professional enough, especially in our country? Who will regulate their conduct? Because a misconduct of an arbitrator is a good ground for substitution of the arbitrator or setting aside of the award. But is it good enough? The parties, the disputants, the litigants are not bothered. They want quick resolution. So setting aside an arbitral award sets the clock back. You start from zero. Substitution of an arbitrator, even if you say that the new arbitrator will continue from the stage where the earlier arbitrator was removed, again makes it a slower process. So is there a way to regulate the conduct? How do you do it? Can you regulate it? One of the ways of looking at it could be self-regulation. But self-regulation requires character, which is, I believe, not commonly found in any system, frankly. And so long as that problem is there, then how do you regulate? Do you have bodies like akin to the bar councils or medical councils, which have some powers at least of regulating? How far do you regulate? The regulation, will it affect the independence of the arbitrator? Will it affect the choice of the parties? Because now there's a thrust towards encouraging institutional arbitration. I think one of the reasons is this, that the institution would be able to perhaps take care of this difficulty of misconduct of an arbitrator. We have seen very often, and it's an elephant in the room, nobody wants to address it, that there are arbitrators who are very able, no doubt, but who are more concerned with billing hours, who are, I dare say, delaying matters. They're looking at the fees rather than the effort that has to be put in. What is to be done of that? Because it's a very sensitive kind of a topic. You have to, because for instance, there's one issue that came up about 6 months ago, that one of the counsel practicing in Bombay High Court was working as an arbitrator. He passed an award. The aggrieved party went to a section of lawyers, you know all of them in the bar here. I call them mischief mongers. They advised the litigant, the aggrieved party, to file a police complaint against the arbitrator. And the grounds taken in the police complaint, which ran into about 110 pages, with judgments, precedents being quoted left, right, and center, alleging misconduct, alleging breach of trust, criminal liability, etc. And the police person saw that 110-page document and issued a notice to the arbitrator. And he came running. Of course, nothing happened of that, because the commissioner took over the matter and said, this is all a civil matter, it can't be a criminal liability. But this is the problem. If it's left unregulated, then these kinds of mischief mongers can do damage to the system. Regulating the conduct of an arbitrator is something really which we need to, do we need regulation, and how do we go about it? This is something you must discuss, although it's not, I don't see it as one of the topics here, but it would help in the process of better understanding how the process can be made quick and therefore less expensive. In commercial matters, you can't say inexpensive. Inexpensive would be matrimonial disputes, and those are real concerns. They're custody matters and so on, family disputes. But when you come to commercial disputes, at least make it less expensive, more efficient, if that can be done. So these are some concerns which I believe the ADR week should address. The whole culture of arbitration in India will change not by amendments in the statutes. If you see the amendments that were brought about in 2015, you had the Sri Krishna committee in 2017. You now have an expert committee which gave its report in February of this year. Further modifications, further amendments are suggested. Howsoever much you change or amend the statute, nothing will happen unless our approach changes, our culture changes. And that will take a lot of effort. I have a lot of hope from young members of the bar, because now, as I remember, I came out of the Faculty of Law in Delhi University in 1994, where I was one of the very few people who used to attend classes, take part in moot court competitions, represent our faculty, etc. Most of the students used to get medical certificates for ensuring their attendance was complete, used to come for the exams and go away, because it was treated as an additional qualification. You couldn't do much, so we still had an entrance in those days. I've cleared an entrance to get admission there, but The idea was to retain the university hostel to appear for civil services exams. So the focus was never on law. Now, fortunately, you have national law schools with the vision of the National Law School being established first in Bangalore and now all over. So the young members of the bar will be more professional, I believe. The culture will start changing, but we can't wait for them to 10 years hence become respected professionals to bring about a change. It has to be here and now. And just see how faith in the arbitral process, in a way, is reduced even from the point of view of the government. If you've seen the notification they've issued in June recently, it says that any dispute which involves liability of more than 10 crores, arbitration clause will not be there in the government contracts. Now, if this country is now zooming towards becoming a powerhouse, infrastructure is being developed, necessarily the government will be involved in such contracts. 10 crores is nothing. Any contract which involves more than 10 crores, you will go for mediation, but not for arbitration. Now, the Mediation Act 2023 is another big change. It's a welcome change. But on the one hand, if the government is saying we are trying to encourage arbitration as an alternative dispute redressal mechanism, then what is this notification? That's another point of debate you should have. But you read the contents of that notification. It says in terms that arbitration has become expensive, arbitration is inefficient, so which indicates that the legislature and the executive, they've tried their best through amendments, etc. The culture isn't changing. So they are saying that we don't have faith now because awards of 800 crores, 900 crores are passed against us. We have to make an effort to show grounds of challenge. We succeed eventually, but we have to deposit these many crores in the court in the meanwhile. Our funds are getting blocked. Arbitrators are not efficient. The process is expensive. So therefore, necessarily mediation. And after mediation, you go back to the traditional courts. The other day I was addressing a conference when I looked up the statistics and I found that only the construction industry, more than 80,000 crores are blocked in the courts. Therefore, let's go for arbitration. But if arbitration is now failing, you go for mediation. And if we don't change our approach, mediation will also fail. Then where do we go? Go back to the traditional courts. And changes in the court system will take their own time. You have, what is the judge population ratio in this country? All of these are fundamental questions, but I won't burden you with them in this ADR week. But the topics are interesting. But you must please also think about these issues of lack of faith in arbitrators. What is to be done with that? That's a very serious matter. We have, most of the time we have, in big arbitral matters, we have retired judges who are doing that. And I had once, before my elevation, I was briefed in a matter, an arbitration matter, obviously in the weekend. So I went there and it was a very well-respected retired Chief Justice of a High Court. And I was disturbed. He was taking phone calls during arbitral proceedings. He took a video call from his granddaughter. What's happening? When this is not the way arbitral proceedings are to be conducted, with great respect. So I walked out of that. I told him, sir, I can't conduct matters like this. I walked out of that, I've returned the brief. But that's not a solution. The solution has to be holistic. We have to think about change of the culture, and I'm sure ADR weeks like these will go a long way. Thank you.
Thank you, sir. I would now like to invite Mr. Raj Panchmatia, partner at Khaitan & Co., to give the vote of thanks.
Thank you, Justice Pitale, for taking time out and coming this morning and addressing the gathering here with your views and suggestions. Many of you may not know, but when we went to invite Justice Pitale, he said that 24th morning, it's a little tough. I'm part of the committee which is organizing the new groundbreaking